Your Honor, I have three cases with Mr. Mawad today. It would be, the last names are Maynor, Moe, and Wayne Scott.
Okay. Good morning. All right. Does anyone that's sitting in the gallery have a case today? What's your name?
Matthew Sinclair.
Mr. Sinclair. I'm gonna write down that. Who's your attorney?
I was just served this summons.
Oh, it's a show cause. Got it. All right, hold on one second. Ma'am, do you have a court case or you're just here to watch?
My granddaughter, Kaylee,
Okay. What's her last name?
Lake, L-A-K-E.
All right. All right, and Mr. Malaro, or wait, I have somebody from MVP hearings. Can I ask who I have?
Miguel Mansour.
All right, thank you, Mr. Mansour. And Ms. Underwood, do you have Mr. Mansour?
I do not.
Figure that out. Mr. Mansour, at this time, you don't have an attorney?
I don't want one.
You don't want one?
No, I don't. I just want to be guilty and be done.
Yes,
Okay, so,
I don't think I'm sorry, Your Honor.
all right, in the matter of the people of the state of Michigan versus Miguel Mansour, file number 25-22176FH. Mr. Mansour is joining us from the Michigan Department of Corrections. Ms. Underwood, what were you going to say?
I believe Mr. Mansour waived counsel in district court for reasons that are explainable, I believe.
Okay. So, Mr. Mansour, this is the date and time set for arraignment in this matter. The felony information I received charges you with, hold on a second, one count of assault of a prison employee that you did being a person lawfully imprisoned in the Harrison Correctional Facility. Assault Officer Watkins, an employee of the place of confinement or other custodian, knowing that that person was an employee or custodian through the use of force, threats of violence, or dangerous weapons while serving a term of imprisonment on or about December 5 of 2024 in Madison Township in the county of Lenawee. That offense carries a maximum penalty of up to 5 years in prison and or a $2,500 fine. Because you are currently housed in the Michigan Department of Corrections, or was at the time this offense occurred, any sentence you receive on this would stack on the sentence you're currently serving. Do you understand that part of it, Mr. Mansour?
Yes.
Okay. Now you do have a habitual offender second offense notice that states that you were previously convicted on or about May 13th of 2020 of homicide, first degree murder in the 16th Circuit Court from Macomb County in the state of Michigan, which means that if you were to plead it to count one with that supplement, the maximum penalty could be up to 7.5 years in prison. Do you understand that, sir?
Yes, I do.
All right. Mr. Sneed, is there a plea offer in this case?
No, Your Honor.
Okay. Is this your case or Mr. Is it your case, Mr. Sneed?
Yes, Your Honor.
Okay. Now, Mr. Mansour, you do have a right to have an attorney represent you on this and all subsequent hearings. You're currently incarcerated. So obviously we would provide that at public expense. We do have a good public defender's office here. Are you sure you wouldn't like an attorney to represent you?
I'm positive. If anything, I'd like to just plead guilty and take whatever you guys are giving me and move on and just finish with the case. Can we do that today?
Okay, all right. Do you understand there's no plea offer?
I understand. I plead guilty to whatever charges. Send me the maximum. I don't care.
Okay, I just want to make sure that you know all your rights. So, Mr. Mansour, can you please raise your right hand for me?
Can you see it?
I'm trying. There you go. Now I can see it. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. You can be seated again. So, Mr. Mansour, you heard that there's been no plea offer made today, and you have waived your right to an attorney. So, do you understand if your guilty plea is accepted, there will be no trial? This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Mr. Mansour, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, sir?
I understand.
Okay, do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
I understand.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Mansour?
Not at all.
All right. How do you plead to the charge that on or about December 5 of 2024 in Madison Township in the county of Lenawee that you did commit the offense under count 1, assault of a prison employee? Guilty or not guilty?
Guilty.
All right. Mr. Sneed, is this plea as charged to count 1 with a sup or without a sup?
With the sup, Your Honor. Thank you.
Okay. Now, Mr. Mansour, you were convicted of homicide first degree on May 13th of 2020 in the 16th Circuit Court for Macomb County. Is that correct?
Yes.
And how do you plead to that habitual offender second offense notice? Guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I do.
Mr. Sneed, are you aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty?
No, Your Honor.
And Mr. Mansour, because you don't have an attorney, you've had no discussions with anyone regarding what a potential sentence could be. Is that correct?
Correct.
Is it your own choice to plead guilty?
Yes, it is.
All right. So, Mr. Mansour, on December 5 of 2024, were you at the Gus Harrison facility located in Madison Township in the county of Lenawee?
Yes, I was.
All right. And where are you currently located?
In a cell.
At where? No, I mean, are you still at Gus Harrison or are you at a different prison?
Gus Harrison. Oh, wait, currently
you're
right
still
now?
there.
No,
Yeah,
I'm not.
yeah.
I'm not. Currently right now, I'm at Marquette Branch Prison.
Okay, thank you. And when you were at Gus Harrison, you were serving on a first degree murder charge. So you were lawfully incarcerated at Gus Harrison. Is that correct?
Correct.
And did you come in contact with an Officer Watkins that works there?
Yes, I was.
Was he a CO or custodian? What did he do there?
He's a correctional officer.
Okay, and did you assault him?
Yes, I did.
Okay, can you tell me what you did to assault him?
Punched him
Okay,
and
all right.
I punched him and he was bleeding, and then I was apprehended, put in cuffs, and held in containment.
Okay. Are you satisfied? And he was working at the time, so he was lawfully employed there, correct?
Yeah, he opened my door for medication for Medline, and I attacked him.
Okay, Mr. Sneed, are you satisfied?
Yes, thank you.
Has court complied with MCR 6.302 B, C, and D?
Yes.
Mr. Sneed. All
Thank
right,
you, Donna.
accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, or the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. And Mr. Mansour, I am going to set this for May 16th at 8:15. And Mr. Mansour, you have a right to be present in person, or you can appear via Zoom. How would you like to appear for sentencing?
Zoom.
Okay, thank you. And do you want an attorney appointed for sentencing? You have that right.
I don't.
Okay. All right. So, Mr. Mansour, someone from the probation department will be getting a hold of you through MDOC. They'll update a pre-sentence report. Ms. Walsh, will that be sent to him at MDOC to review it, because he won't have an attorney to review it with?
Not sure how that works.
Okay. So, Mr. Mansour, there's a couple things we can do. We can appoint an attorney with you so that they can review that PSI with you before sentencing. That would be easy. The other option is, if we're not able to get a copy to you in time to review, I can put you in a breakout room. Well, Ms. Walsh, I guess we'd have to provide him a copy. So, I can have the PO review it with you that morning, or we can send it to whoever you have there at MDOC as a counselor. Or do you just want an attorney appointed to review that with you before sentencing?
I'm the counselor.
Okay. Okay. So we will, Ms. Walsh, make sure we make a note that somehow the PSI gets to him before sentencing. All right.
Yep, I just checked.
All right.
Stevenson, yeah, we have to provide one somehow.
Okay. All right. So Mr. Mansour, when they meet with you, be truthful about your background, the events that occurred, and we will see you back here on May 16 at 8:15 in the morning via Zoom. Thank you.
Thank you.
Thank you, Mr. Mansour. All right. So, sir, do you have a court case or you're just watching?
I have a court hearing today.
What's your name?
Michael Newsome,
All right, Mr. Newsome, hold on a second.
8:30.
At 8:30, okay.
Off court hearing.
So Mr. Newsome, yep, there we go. Ms. Underwood, I have Mr. Newsome and I have Ms. Williams from the Attorney General's office. So do you want to take care of Mr. Newsome?
We can do that right now, Your Honor.
All right, Mr. Newsome, why don't you come on up to the podium there. Mr. Mawad.
Hi, Judge.
All right, Ashley Beach, I see you've logged in. Are you looking for a case that I have?
Yes, we are the foster care agency working with Alexia Row, and we're told that she has a criminal hearing this morning.
Yep, okay. Yep, just stay with your video off, and you did, and you can observe. Thank you.
Thank you.
All right. This is in the matter of the people of the state of Michigan versus Michael Robert Newsome, file number 24-22068FH. This is the date and time scheduled for a first pretrial in this matter. Ms. Underwood, how do you wish to proceed today on behalf of Mr. Newsome?
Your Honor, I spoke with Ms. Brenner in this matter. I know Ms. Williams is here this morning. And Mr. Newsome is doing very well with his payments. So we believe a 90-day adjournment would be appropriate in this matter to allow him to take this down, looking towards some sort of delay at some point, Your Honor.
All right. So, Ms. Williams, your name says C. Williams. So for the record, can I have your full name and your P number, please?
Clarissa, Clarissa Williams, P84270.
All right, thank you. Is that correct, Ms. Williams? Any objection to an adjournment?
No objection, Your Honor.
All right, so Ms. Adams, I'll need a notice of hearing for Mr. Newsome. So, Ms. Underwood, June 18 for a couple months. How far out do you want it?
Probably 90 days is okay on this one, Your Honor.
All right, how about July 16?
7:15, thank you.
7/16 at 8:30 in the morning. So, Mr. Newsome, are you working?
Yeah,
Okay, so we're gonna get you a notice of hearing. You can appear via Zoom.
I just like to come because I don't know how to do it, so I just come down.
It's okay. You can come in person, but I just didn't want to get you in trouble at work.
Oh, no, I'm.
Okay, have a seat on that bench right behind you and my staff will get you a notice of hearing. Yep, right there. So we'll see you back on July 16th at 8:30 in the morning. Thank you, Mr. Newsome. Thank you,
So
Ms.
there's no
Williams. Do you have
step
anything?
There's no step to adjourn required, Your Honor?
No, he's in person. I'm gonna do the notice. Ms. Williams, do you have any other cases this morning?
Yes, an arraignment is on my schedule for a Jeffrey Elliott. Sorry.
I believe Mr. Malero is taking Mr. Elliott, Your Honor.
I have Elliott for a drug case. Does he have a pretrial too?
Judge, he's got some VOPs that just got filed, and he's got an arraignment on the drug case and the friend of the court case.
Okay, all right. All right, he's in jail.
Yes.
Keep up the good work, Mr. Newsome.
Thank you, I appreciate it.
You're welcome. Bye. All right, so. All right, Mr. Sinclair, you can come on up. Yep, come on up to the podium. This is in the matter of the people of the state of Michigan versus Matthew Richard Sinclair. File number 24-21920FH. Mr. Sinclair, we are here on, Mr. Adams, I don't have paperwork on.
I believe it says it's an arraignment.
No, I don't have the paperwork, so we have to hold on. So, Ms. Adams, I don't have the paperwork on the show cause. I
Okay,
just
so
have the, well, wait a second. I do, I have a copy, it's just not in the file. All right, so Mr. Sinclair, we're here today on a request and summons for probation violation, which alleges that you violated a no contact order on March 14 of 2025 and were charged with domestic violence and interfering with the communication device. So have you been arraigned on those new charges?
I don't believe so, no.
Have you been to court on those new charges?
I did, it was for like a pretrial or.
When's your next court? Hi, this is Judge Anselone. I am ready on, I don't remember who I said I was ready on now, Jeffrey Elliott.
Elliott. Okay, I'll get him.
All right, thank you.
Right, right.
So, so you had a pretrial. When's your next court date?
Monday, the 14th.
Okay, so you were arraigned except for pretrial. Now you have something on Monday, the 14th of April, so next Monday.
Yep.
Okay, and you have an attorney on that?
I do, yes.
Who's your attorney?
It's someone from the public defender's office. I can't remember.
Man or woman?
It's a woman.
Rhonda Underwood? Okay,
She's younger lady, taller, a little bit taller than me, brunette.
okay.
She just actually poked her at her.
Carly Zilke, okay. All right, so, Mr. Sinclair, you are technically facing up to 93 days in jail on this charge. If you are convicted of that new violation of probation, or if you plead guilty today. Obviously, that case is still pending. So anything you say on the record today could be used against you in that proceeding in district court. Do you understand that?
I do understand.
All right, so you have a right to have an attorney represent you up here. Would you like an attorney appointed to represent you?
Yes, Your Honor.
All right, so Miss Underwood, what I'm gonna do is enter a plea of not guilty, and Miss Adams, could I get a court date after April 14? Like maybe the next week? And I'll need a notice of hearing.
Are we looking for Wednesday or?
We can do it Wednesday.
April 23rd?
All right, so we're gonna set this over to April 23rd at 8:15 in the morning. Have a seat right behind you. We'll get you a notice of hearing. Understand there is no contact.
Okay.
All right, thank you. Okay,
Thank you, Your Honor.
all right, Mr. Elliott, is that you at the jail?
Yes, ma'am.
All right, let me grab all your files. All right, so this is in the matter of the people of the state of Michigan versus Jeffrey Allen Elliott. We have file number 23-21200FH. Mr. Elliott, this is a violation of probation charge, which alleges that you violated an order of probation by being arrested and charged with controlled substance possession of methamphetamine on or about March 19th of 25, and that you're arrested for that charge. On that file, the maximum penalty you're facing if you are found guilty or plead guilty to that violation could be up to 4 years in prison. On file number 21-20212FH, you're facing the same allegations for violation of probation. On that file, you were convicted of assault with a dangerous weapon. So if you plead guilty or found guilty, you could be facing up to 4 years in prison. And then we have then on file number 25-2203FH, you're set for arraignment, as well as on file 25-22204FH. So I have Salvatore Milaro appearing on behalf of the two arraignment files. You said Clarissa, right? Ms. Williams, appearing on the one violation of probation file for the public, or for the Attorney General's office. And who's my prosecutor on these new files for arraignment?
I believe that Mr. Hartong's Your Honor, but
Your Honor, I can handle that today, sure.
All right, and then I have Douglas Hartung appearing on behalf of the Lenawee County Prosecutor's Office. So, Mr. Elliott, you do have a right to have an attorney appointed on the two violation of probation files to represent you. Since you already have a public defender on the other two, I'm going to assume that you're eligible for a public defender. Would you like a public defender appointed to represent you on the violation of probation files?
Yes. Can I have Mr. Milaro as well?
I can't say yes, but it's up to Mr. Milaro whether he keeps them all.
Judge, I will be representing Mr. Elliott.
All right, so we will appoint the public defender's office on the two violation of probation files, which more than likely we're not going to do much on today. So, Mr. Milaro, it is the date and time set for arraignment on the two new arraignment files. Do you waive the reading of the felony information?
Yes, Judge, with respect to, do we have a particular one you want to start with?
Well, I just want to know if you want to waive the reading of the information. And
As to both cases?
yes, sir.
Yes, Your Honor, we acknowledge receipt of the informations with respect to both cases and waive their reading, waive any defects in time and place of service. We would stand mute as to all charges and ask the court to enter a not guilty plea. We'd also ask the court to enter a not guilty plea on the probation violations. And we'd ask to be able to address bond in these matters.
All right, so Miss Adams, on the docket, I only show arraignment on file number 25-22203. Is that what you have, Miss B? I don't show file number 25-22204.
Yes, I just noticed that.
And then I don't, do I have the violation of probation files on there?
We just got those yesterday.
What page are they on?
They weren't.
Oh, okay. All right. So, okay. So you want me to enter a not guilty plea on everything? And then, how far out would you like pre-trial, Mr. Malaro?
I think 30 days should be fine, Judge.
Now, he does have a habitual offender third offense notice on the 2 new files. So he is looking actually at a maximum penalty of up to 40 years in prison on those delivery charges. So I will enter a plea of not guilty on his behalf. And you said 2 to 3 weeks.
I think 30 days should be sufficient.
About May 14.
Sure.
All right, so we'll set it over for a pretrial on May 14 at 8:30 in the morning on all the violation of probation, as well as the 2 arraignment files. So, Mr. Malaro, you said you wish to address bond?
I would, Judge. Your Honor, as to the substance abuse case, I believe bond set at $1,000 cash security. We're not arguing for that bond. On the child support case, I think the bond is set at something like $17,700. He owes a considerable amount of money, Judge, according to the allegation. However, I would point out that 2 days ago, Judge, I received a fax from Michigan Pallet where it indicates he is employed. They faxed me a copy of his wage stub. As the time he was arrested, he was making, it appears to me, $127.47 per pay period on his child support order. Mr. Elliott, also with respect to these new violations which were recently filed, indicate that he was charged with a crime. He does his cloak with the presumption of innocence. And it seems confusing to me because it indicates that both the same offenses are both a technical and non-technical violation. Mr. Elliott, I've represented him in the past. He's appeared at my direction at all court appearances. He was working within the county, so I do not believe there's any, there's a low, if not negligibly low probability of Mr. Elliott fleeing the jurisdiction of the court. I think that he does not present a danger to the community, and if the court needs to be assured of that, they can order him to have testing for substance abuse. They can order Mr. Elliott to wear a tether, so if they're concerned about his whereabouts. But again, he has been in the county, he's working in the county. The fax I received indicates he still has employment at Michigan Pallet. So I'd ask Judge that the bond in the child support matter be reduced to perhaps $2,500, and that the bonds in the probation violations be reduced, or there is no bond set at this point, but those bonds be set at $1,000 cash or surety. I think that would be a sufficient indication of Mr. Elliott's seriousness of taking these matters, appearing, and making sure these matters get resolved in a favorable manner to all concerned. That's our request, Judge.
All right, so Mr. Millar, on the 2 new files, you're saying bond was set at 1,000 cash surety, right?
If you're talking about the probation violations?
No, I'm talking about the 2 new files.
On the drug charges, it was my understanding bond was set at $1,000 cash or surety.
Yes, so you're not asking for a reduction in that one.
Correct.
And then on the 2 probation violation files, there's no bond usually. So Ms. Williams, from your records, are you able to verify that he's been making steady payments on his child support?
No, Your Honor, I'm having trouble getting into my system. It is now.
Okay, let me call real quick. I can find somebody and get that information. Who's an E? Just. Hi, Ms. Stevenson. This is Judge Anzalone. I am calling on a Jeffrey Elliott. I'm here with the Attorney General and his attorney, and I would like to, let me see if I can get the front of the court file number.
Yep.
So it's Jeffrey Elliott, and let me see here. I don't have front of the court file number. Miss Elliott, do you have our Lenawee County FOC file number? Oh, it might 2009-34751. Does that sound right?
Oh, 34751. Well, there definitely is one with Elvista.
Okay. Can you verify what payments have been in the last 6 months? We've had payments.
Let me look here.
Your Honor, if I may, I'm having the document I have emailed over to you.
Okay, so on March 3rd, you know what, though, I don't check and make sure. Oh my goodness. All right, let me go someplace else because this is going to show payments, but he's got several cases. So let me figure out what went to this case.
Has he been making payments?
We have had payments. We've had 1, 2, 3, 4, 5 payments in 2025, and those are the first payments that we've had since 2023. They've been 1, 2, 3, 4, 5 payments of $127.47, but I doubt they all went to her.
Because he has other cases.
Because he has other cases. Yeah, if anything, and I don't even know, I can't tell, there's just so many. If he has a case where there are minor children, then probably nothing went to this case.
Your Honor, I was able to get into.
Hold on, Ms. Stevenson.
I'm sorry.
Go ahead, Ms. Williams.
I just want to verify, this is file 25-483-FY.
The felony file, you mean?
Yes, I just want to verify that I'm looking at the right amount. Because for this.
So the case that you're here on is 23-21200FH. I'm not sure what the front of the court file number is. Mr. Malaro said you sent something to me, but I don't see it.
That Ms. Williams was referring to the district court file number, I believe.
Oh, okay.
That's a district court file number, not a circuit court file number.
Okay.
I see. I do have, it would be 23-21200.
Okay.
Okay, I can help a little bit with some of the background on this if the court would like me to. Ms. Williams was not at the district court hearing when Mr. Malaro had Mr. Elliott waive the preliminary examinations on both files. Bond was discussed in considerable detail at that point in time. My guess is that the bond on the possession with intent to deliver case, it was probably set a little lower than it normally would be, because the bond on the child support case was set, I believe, and Mr. Malaro will correct me if I'm wrong, originally between $75,000 and $80,000 to match the arrearage amount on the cases. And the bond was subsequently reduced to the current level, about $17,000 or so, based upon the statutory requirements. They could only be reduced so much. Again, Mr. Malaro will step in and correct me when I'm wrong, but the judge in district court elected not to reduce it down any further. At that time, Mr. Malaro was asking for a $5,000 bond on the Southport case and keep the drug case where it was because she didn't feel she could change the statutory amount set on the bond on the child support matter due to the large amount owed. So, my position is that, again, I don't have any skin in the game in the child support case. That's Mrs. Williams' case, but I'm just trying to update the court. And I suspect if there had not been this other case, the bond on the drug case would have been a little higher than it is right now. I'm not asking for it to be increased.
Okay, and I think it's confusing because he actually has a violation of probation on a felony child support case and a new child support felony case. So that's where I was a little confused. I'm sorry. So Ms. Williams, do you have any of, and Mr. Malaro was asking for it to be reduced to 2,500, I believe. Mr. Malaro, is that correct?
Yes, Judge. I mean, he's working and obviously they're taking it out of a paycheck. I think the important thing is that he pays his child support. Doing that, I think that's good cause to depart from the statutory requirement. And I mean, what Mr. Hartung, in principle, I think is accurate, but I think it's important that Mr. Elliott pay his child support. And this is and the reason though I'm asking for a further reduction is I now have, it's been documented to me by Michigan Pallet, his employer, which I think we sent it over to Mrs. Adam, that he is employed and he has employment available. So that's why I'm asking for it to be 2,500 cash.
Okay, so if he has a case that emerges only, no money is going to that case because it's all going to go to the active cases unless he's actively coming in and paying extra money directly on it. So Ms. Williams, what is your position today to a bond reduction on that file? I will say that Mr. Elliott does show up for court. I'm glad he is employed. I'm going to guess not a whole lot's going to some of his files, but with that being said, what is your position to reduction in bond for 2,500?
That's my concern. The file that I'm looking at, that's why I was just trying to verify. Not much has gone to this file. I see something in March for $412, and 319 of that went to the arrears. And it looks like there's a total of $71,000 in arrears. So that's concerning to me. However, it is important that he's employed, and we wouldn't want to see someone lose employment. It's already been reduced. It's clear that he can't pay the $17,000. I would just defer to the court today, just based on the fact that he has employment, and I wouldn't want him to see him lose the employment. But we do have the statutory amount it's already been reduced from. So based on those guidelines and administrative decisions within our department, I can't necessarily support a further reduction.
All right, well, I do have discretion on this. So Mr. Malaro, it would be a $2,500 cash bond. You'd have to pay $2,500 on the child support case. Okay. All right, so what I'm gonna do is on file number 25-22204FH, reduces bond to 2,500 cash. Obviously that would go to the front of the court. I'll leave the other bond where it is, and Ms. Walsh, on the violation of probation, he hasn't absconded or anything. He's been reporting, it's just the new charges, correct?
I
don't see.
Well, his first violation was for failing to report.
But back in February, January of last year?
January of 2024, correct.
Has he been reporting since then? Has he been reporting since then?
I don't believe he would have been reporting until he was arrested recently. Double check.
That we took care of. New file. Hold on, Mr. Elliott. Sounds like you have as many files as you have kids right now, so hold on. I do show.
Double check, actually.
I do show that we appointed public defender back in November. I sentenced him back in November. Has he been reporting since November?
Look. Yes, he was released in December. Reported in January. February. Yes.
All right, so I'm gonna give you a PR bond on the 2 violation of probation files, Mr. Elliott. I'll leave your bond at $1,000, cash surety on file number 25-22203FH. On file number 25-22204FH. I'm gonna set your bond at 2,500 cash. Mr. Elliott, get a second job. You need to be hammering on payments. If you come here in person, you can direct where the payment goes if you pay here. Pay it online.
I can actually pay a little extra each week if need be, another $25 or $50 actually each to pay right down.
That's why I'm saying, get another part-time job. You know, it's gonna impact what happens. If you
They
don't
take the
report to
127
probation.
directly from my check, and I can pay
care
extra
how
as
much-
well.
Listen.
Mr. Elliott, let the judge talk.
I don't care how much they take out of your check. You better know what you owe on each case. And then you better pay extra on the files that you're here for. I don't care how many jobs you gotta get. If you're picking up sticks, picking up pop bottles, we can only take a certain amount out of your check. That doesn't mean you don't have to pay the rest of it. Do you understand? Yes or no?
Yes, I do.
If you don't show up for court, if you don't do what we're saying, we will issue another bench warrant for you. Do you understand?
Yes, I do.
Most people don't get this opportunity, so we will set all of these for pretrial on, I might have said the wrong date. I think it's May 14 at 8:15 or 8:30 in the morning. And Mr. Malaro will just do the notice of hearing because we're doing them anyway, because it was an arraignment, and I'll enter a plea of not guilty on all files.
Your Honor, one last thing.
Yes.
The drug case, that is there a testing requirement for Mr. Elliott to work with?
Yes, Mr. Elliott. Yep. All right, Mr. Elliott, I am going to require that you test as required through our pretrial services or probation. I'm sure they're testing you on your probation, correct?
And he has never tested me on probation, but I got a paper already sent over here from Darren Cost that I need to get with him directly as soon as upon release of the event, to do twice a week.
When you get out of jail, walk over to the courthouse, go to the 3rd floor to the clerk's office, report to probation, or let that check in with them, but then also ask at the clerk's office for Mr. Coast, okay?
Yes, ma'am.
All right, and we'll put you on random testing, and not to use any illegal controlled substances or alcohol. So I'm sure that's a probation term as well. All right, thank you, Mr. Elliott.
Thank you.
Okay, so, looking, is that it now, Ms. Williams?
Yes, Your Honor.
Thank you.
Thank you. Have a good day.
You too.
Middle floor.
Hey, this is Judge Anslone. So I am ready for Kelly Moe. I'm gonna give you a couple, okay?
Okay, Mo, okay, I got him, okay.
Israel Veila.
Okay, he's downstairs, I'll let them know.
Rodriguez Loftton.
Oh, Lord.
I know.
All right.
And James Rener, and that's it for now.
Okay, is that the order you want them in, or?
No, just
Okay.
whenever, whoever you can get to me the quickest.
All right.
All right, thank you. Bye. Okay. Do you have a court case today?
Pre-trial,
What's your name?
Shane Reamer.
All right, Mr. Reamer. I'm gonna go. All right, who's your attorney?
I'm representing myself.
Okay, always questionable. Come on up. This is in the matter of the people of the state. Oops, I must have hit a button. All right, this is in the matter of the people of the state of Michigan versus Shane Leroy Reamer, file number 23-21665FH. This is the date and time set for a final pretrial conference. Today was the motion deadline for both motions and motion in limines to be heard. Jury instructions were to be provided to the court by April 2nd, along with any proposed voir dire questions. We are set for trial on April 22nd of 2025. Mr. Reamer, you are charged with police officer resisting and obstructing causing injury, which carries a maximum penalty of up to 4 years in prison. Police officer assaulting, resisting, and obstructing, that carries up to 2 years in prison. There's 2 of those. And then there's a disorderly. And what is the plea offer in this file?
Your Honor, the people have offered to a plea of 2 counts to attempted R&O.
All right.
So 2 misdemeanors, and we would kill a brute to no upfront jail.
All right. Mr. Reamer, the plea offer in this case was to plead to 2 one-year misdemeanors with no upfront jail. And there'd be like 12 months or so of probation, some minimal fines and costs. Do you understand that? All right. Now, Mr. Reamer, you know, I'm assuming you graduated from high school, right?
8th grade.
You went through 8th grade, and this is a felony that could result in you going to prison. Why don't you stand in front of that podium for me? So do you understand an attorney can help guide you through the legal process?
Yes, I tried to have, I almost had a public defender. Unfortunately, she wasn't representing me appropriately. I had asked for another one, but.
So I have no authority over who gets appointed. You're appointing an attorney.
I understand that, but when they're not representing you appropriately.
Okay, I didn't ask that. I'm just saying you have a right to an attorney. I know the attorney you're referring to. She's diligent. She works hard. Maybe you didn't like, I know when I was a public defender, sometimes my clients didn't like what listen to me, I'm talking. My clients didn't like the things that I told them. But, you know, her job isn't to do what you want. Her job is to represent the law. So you understand at this point, you can hire an attorney, or you can go with the public defender and whoever they assign you, or you can go to trial pro per with no law degree, no experience, and risk going to prison. You're going to represent yourself.
I'm gonna represent I ain't got no choice but to
Have you provided your jury question, the voir dire questions? Because if you haven't, they're waived.
If there's no,
if they were due.
If there's evidence provided against me, I have a right to defend myself using that very same.
That wasn't the question I asked you.
You
do have a right to defend yourself, Mr. Reamer. I'm just.
My right for violence.
I'm talking, you're not. If you don't stop talking and listen to me so I can go through my speech, I will send you over to the jail. Do you understand? All right. You have not filed any motions. Jury instructions were due and voir dire questions were due. You have not provided those. We gave you a copy of this. So do you understand what I've received is what will be used? Yes or no?
I will be allowed to ask my questions.
What question?
When I'm cross-examining, I will get my.
I'm talking about juror question. I'm talking about jury instructions and voir dire questions. You understand now? You didn't file, listen. I know, but you waived that because you have not provided them. Do you understand that? Do you understand that?
No, I don't. I don't
Okay.
understand that. I didn't understand that.
Okay, well, I
That's why
can't advise you of the law because I'm not an attorney, I'm a judge.
No, but you're
So,
looking at the case and you've been presiding over my case for 3 years now.
I know, it's fine. You're
the
gonna
one-
go to
You're the one
trial.
that signed the warrant for my arrest while I was in jail.
I don't know that, I don't
Yes,
remember.
you did do that.
Okay, I'm allowed to do that.
No, you violated my rights. as well.
Okay, well, you have options. You can file a complaint with the JTC if you'd like. So are you prepared to go to trial?
Absolutely.
Have you provided your witness list?
I haven't yet, but I will.
Okay, that was due.
My witness list was provided when Ms. Underwood was my attorney.
Okay.
And my witness list is.
Have you subpoenaed any witnesses that were not on the prosecutor's raised just eyewitness list?
Yes, my witnesses are the ones that was there at the scene.
No.
And, yes.
Do you understand that you have to provide a witness list and you have to provide a copy to the prosecutor? Do you understand that?
Prosecutor, I gotta provide what to him?
So if you're gonna have witnesses at trial, you need to make sure the prosecutor has their name and contact information so that they could interview them prior to trial if they wanted. Do you understand that?
Well, they got all that information.
They do?
Yes.
Okay,
Yeah,
so,
my witnesses are my parents and my aunt.
okay, I don't know, are those on, if they're not on the people's witness?
Curtis, Penny,
Okay,
and Rose.
if you haven't provided a witness list and they're not on the people's list, you understand you won't be able to call them.
Okay, I will provide the information. I
Okay.
can provide that information. Yeah.
I'm just telling you. So you need to make sure that there's a witness list in the file that was provided to the people.
So I gotta re-provide it.
I don't know. Go back and look at what witness list has
I'll
been
do that.
filed, their name, their contact information. And then any subpoenas you have to do, if you have to subpoena anybody to be present, you need to get those filed this week. And then the court signs them and then you serve those people with those. Do you understand? Now, do you understand when we go to trial, a lot of times some of the questions you ask or he asks may be objected to, and it's not personal, it's just, you know, we have to follow the law.
Yeah.
Okay,
I'm allowed to object too though, right?
huh?
I'm allowed to object too.
You are, and then you have to provide the basis for that objection. Okay, so you need to understand your objections. So you might want to do some research to understand.
I've been doing.
Good, good. You sure you don't want a public defender for trial?
Huh?
You sure you don't want an attorney for trial?
I'm not gonna take any of the attorneys from here because they're all corrupt.
Well, I don't agree with that.
So,
All right, this matter is continued to trial. Trial is set for 9 AM. I expect everybody here by 8:30 in the morning, okay? All right, very good, thank you.
we're on the 22nd.
22nd. April 22nd at 9 AM.
And my father, he's got shingles right now, so when he's called in as a witness, it'll have to be on too. Cause he got shingles.
Well, it's a couple weeks from now.
You know, shingles don't just go away overnight.
No, they don't. I've had them. They're awful. So do you have any objection to a witness appearing via Zoom?
No, Your Honor.
Okay, he can appear via Zoom then. Thank you.
Thank you, Joe.
All right.
Judge, it's Mo that you have in front of you and Rener is waiting in the.
I can't hear you. I'm so sorry.
You can't hear me still?
I can hear you now.
Okay, this is Mo and you got Rener waiting in your waiting room on number 4 from the jail.
Okay, great.
Okay.
Thank you.
You're welcome.
Thank you.
Good morning.
All right, hold on there, Mr. Mo. I gotta find where everybody's at. There we go. Jail. So many jail rooms. All right, so Mr. Malaro, let me grab Mr. Mo's file. This is in the matter of the people of the state of Michigan versus Kelly Dwayne Moe, file number 24-21931FH, 24-22090FH. I have Elias Mawad appearing on behalf of Mr. Moe, and I have Douglas Hartung appearing on behalf of the people. This is the date and time set for, get there. This is a pre-trial conference. So, Mr. Mawad, how would you like to proceed today on behalf of Mr. Moe?
Judge, we have pleas on Mr. Moe, Mr. Wayne Scott, who's somewhere in the Zoom room, and Ms. Manor. For Mr. Moe on the Hudson case. So there's 2 cases, but on the Hudson case, he's going to be pleading guilty to B&E. That's the 10-year. And Mr. Hartung has agreed to dismiss the other counts. Habitual subs are dismissed, and any initial incarceration is capped at 1 year. Any restitution is ordered by the court. That's on the Hudson case.
All right, so Mr. Hartung, is that the 24-21931FH file?
Yes, that says Hudson on it, yes.
But it
I don't
says
have the
City of
numbers in front of me.
Hudson, there's 3 counts of B&E, 1 count of burglar tools, 1 count of larceny in a building, an R&O, and a habitual offender 4th offense notice.
That's correct. That's all
Right,
correct.
is he pleading guilty to count 1?
Yes.
Yes.
Okay, so all other counts will be dismissed, including the habitual offender notice, Mr. Hartung?
Yes, Your Honor.
And then a cap of 1 year in the Lenawee County Jail is his initial sentence,
That's correct.
including probation. All right. And then we have one other file. Let me see what this one is. And this one is a City of Morenci file. What's happening on file number 24-22090FH.
So Mr. Moe is going to be plead guilty to the 4-year felony, which is the larceny in a building. The other counts and habitual subs are dismissed. It mirrors the other case where there's initial incarceration capped at 1 year. Any restitution as ordered by the court.
All right. Is that correct, Mr. Hartung?
Yes, Your Honor. And in all three of these cases, there is considerable restitution being claimed by the victims, as a tremendous amount of copper piping was taken out of these buildings and sold by the defendants.
Okay. Okay, so Mr. Moe, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, so that room has kind of wonky audio, so
Yes,
I'm gonna
ma'am.
need you to scoot up a little bit, and then you can yell at me a little bit.
All
and you
right.
won't get
Yes,
in
ma'am,
trouble
I do.
today. Okay, thank you. So, Mr. Moe, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention on file number 24 dash, let me see here, 21931FH to plead guilty to count 1, breaking and entering a building with intent, which carries a maximum penalty of up to 10 years in prison?
Yes, ma'am.
All right, and is it your intention on file number 22090 to plead guilty to count 3, larceny in a building which carries a maximum penalty of up to 4 years in prison?
Yes, ma'am.
All right, Mr. Moe, do you understand the Killebrew agreement that was struck between the prosecutor's office and Mr. Mawad and you would mean that you would serve, your initial sentence would be 1 year in the Lenawee County Jail plus probation, fines and costs, restitution. Do you understand that?
Yes, ma'am.
And then all other charges, including the habitual offender notice, will be dismissed at the time of sentencing.
Yes, ma'am.
All right, and okay. Are you
Hey, Judge.
satisfied with your turn? Yeah.
Judge, it's up to 1 year. I say that because I'm not sure what arguments I'm going to make at sentencing, but Mr. Moe's been in almost 8 months anyway, but I just want to let you know it's up to 1 year. That's all.
Is that correct, Mr. Hartung?
Yes, Your Honor. Capped at 1 year. That's correct. Up to 1 year.
All right, I'm gonna change that.
Sorry, Judge.
No, I just didn't hear that part. Okay. All right, so, let's see. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Hartung?
Yes, Your Honor.
Mr. Mawad?
Correct, Your Honor.
And Mr. Moe, is that correct as far as you're aware?
Yes, ma'am.
So if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, have witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Mr. Moe, do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Moe?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right, Mr. Moe, on file number 24-219 31FH, how do you plead to the charge that on or about June 1 of 2024 in the city of Hudson in the county of Lenawee that you did commit the offense of breaking and entering a building with intent? Guilty or not guilty?
Guilty.
All right, and how do you plead on file number 24-22090F8 to the charge that on or about the time period of July 25 of 24 through July 29 of 2024 that you did commit the offense of larceny in a building? Guilty or not guilty?
Guilty.
All right, has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that, Mr. Moe?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Hartung?
No, Your Honor.
Mr. Mawad?
No, Your Honor.
All right, so other than the agreement placed on the record, Mr. Moe, has your attorney promised you any particular sentence or estimated what your sentence will be in terms of fines and costs, length of probation?
No, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right, so Mr. Moe, we're going to start with file number 24-21931FH. Mr. Moe, on June 1 of 2024, were you in the city of Hudson in the county of Lenawee?
Yes, ma'am.
All right, and were you with Caitlyn Reamer and Benjamin Wainscott?
Yes, ma'am.
All right, and did you enter a warehouse located at 432 East Main Street?
Yes, ma'am.
All right, and did you know who owned that building?
No, ma'am.
All right, did you have permission to enter the building?
No, ma'am.
When you entered the building, was it your intention to steal items from that, whether it be copper or other items that might be in the building?
Yes, ma'am.
Right, and so when you were in there, you did steal stuff and take it out?
Yes, ma'am.
Mr. Hartung, are you satisfied with that?
Mr. Moe, how did you gain entry into the building?
The back door is already busted.
Through the back door?
Yeah.
Okay, thank you. I'm good, Your Honor, thank you.
All right, so Mr. Moe, we're gonna move on to 24-22090FH. So Mr. Moe, during the time period of July 25 of 2024 through July 29th of 2024, did you go to the city of Morenci in the county of Lenawee?
Yes, ma'am.
And were you with Caitlyn Reamer and Benjamin Wainscott?
Yes.
All right, and did you enter a storage building there? Maybe
Yes, ma'am.
555 West Main Street?
I couldn't tell you it's the address, but yes.
All right, would you agree that well, you entered a storage building there, correct?
Yes.
Did you have permission to enter that building?
No, ma'am.
All right, and when you entered it, did you steal copper wire?
Yes, ma'am.
And that was to defraud the owner of the building of the value of that copper wire?
Yes, ma'am.
Okay, Mr. Hartung?
I'm satisfied. Thank you, Your Honor.
All right, has
Satisfied.
court complied with MCR 6.302 B, C, and D? Mr. Hartung?
Yes, Your Honor.
Mr. Mawad?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. I am going to set sentencing for May 16. Are you available that day, Mr. Mawad?
Yes, Judge.
All right, May 16 at 8:15 in the morning. Mr. Moe, do you wish to appear in person or via Zoom?
It don't matter to me.
Zoom.
Is Zoom open?
Zoom's fine.
All right, we'll do Zoom. All right, Mr. Moe, someone from the Michigan Department of Corrections is going to go over to the jail and they're going to meet with you. They're going to ask questions about your background and the events that occurred. Be truthful with them, and then they'll prepare a pre-sentence report. We will provide that to Mr. Mawad, and he will review that with you before sentencing, and we will see you back on May 16 at 8:15 in the morning, thank you.
Kelly, make sure you're honest about your addictions too, your addiction issues. All right, very good.
All right, very good, thank you. Okay, so I have Mr. Veila and Mr. Rener. Let's see who's in my waiting room. Mr. Moy, do you have Wayne Scott? Oh, I see them. They're together. They're together. Miss Underwood, do you need to talk to Mr. Find out. Mr. Rener real quick?
I believe.
Do you need to talk to him or no?
Judge, Mr. Rener is my file and I do not need to speak with him.
Okay. Are you going to be pleading today or setting another date?
Your Honor, he has a felony that's coming upstairs. It'll be arraigned next week. So if we could just set this over.
Just hold on. I was just asking a yes or no question, so give me a minute so I can call the case. All right. In the matter of the people of the state of Michigan versus James Rener, file number 22-21119FH, 22-21120FH, and 21-20539FH. I had Miss Underwood, but it's actually Mr. Milaro appearing on behalf of Mr. Rener, and I just need appearing on behalf of the people. So when is his other file coming up, Mr. Milaro?
I expect he'll be arraigned next week on that.
So do you want this set over next week or 2 weeks after that?
Next week, Judge, we're thinking maybe we can get it resolved by then.
Okay, I'm going to set this over to April 16th at 8:30 in the morning, Mr. Rener. Mr. Milaro, if a resolution is reached, I'll take a plea on Tuesday or Monday to just help you out there, all right?
Sure.
All right, Mr. Rener, I'll see you back here next Wednesday. Thank you.
Thank you. Thank you, Judge.
Okay. Thank you. And Rhonda, you do have Israel Veila, yes or no? Do you need to talk to him?
Yes. I don't need to talk to him, Your Honor.
Is he pleading or are you getting another date?
No, we're just we're entering a not guilty plea and setting this matter for a pretrial. Mr. Brenner, Mr. Veila
Hold on. So in the matter of the people of the state of Michigan versus Israel Veila Jr., file number 25-22210FH. Miss Underwood, this is a date and time set for arraignment. Do you waive the reading of the felony information?
We would waive the reading of the information, Your Honor. And
I do
acknowledge its receipt and the receipt of the people's witness list. We would ask the court to enter a not guilty plea on Mr. Veila's behalf and set this. Your Honor, Mr. Veila has a new matter down in district court. So I would ask for the court to set this for 2 weeks, or Your Honor, for a pretrial perhaps.
And I think the new matter in district court would be a violation of his bond conditions in circuit court. Just for your knowledge, I do have some information regarding that. So Mr. Veila, I'm going to enter a plea of not guilty on your behalf. And I'm going to set this over to April 23rd. Is that enough time, Ms. Underwood?
I think so, Your Honor.
All right, I'm going to set a pretrial for April 23rd, Mr. Veila, at 8:30 in the morning, and we'll do the notice of hearing because it's an arraignment. Mr. Veila, thank you. You have a good day.
Yeah.
All right. All right, Benjamin and Caitlyn. So Benjamin Wayne Scott, Caitlyn Maynard. You can unmute your device and start your video so I see who I have there. Mr. Loftton, you have, who's your attorney? Mr. Loftton, you have Mr. Milaro. Mr. Milaro, yes or no, do you expect a plea today or setting another date? Oh, no, wait, we still have. Say it again, Mr.
We're going to be setting another date.
All right, in the matter of the people of the state of Michigan versus Rodriguez Damon Eugene Loftton, file number 24-21769FH. I do have a finding and order on competency that was provided to the court for today's date. And let's see. All right, so we are still waiting on a bed, it appears, Mr. Malaro, is that correct?
That is correct, Judge. We received a March 27th update that indicates they believe Mr. Loftton can still be restored to competency. That is authored by a Dana Conweck, licensed master social worker and certified forensic examiner. So we'd ask for an additional date, perhaps 30 days, so we do not lose track of this, for him to get treatment.
All right, so I'm gonna set this out to May 21 at 8:30 in the morning, and Mr. Loftton, it's my hope soon we'll have a bed for you with the state of Michigan. I apologize for the delays, and we'll check back with you before that and on that date, all right, Mr. Loftton?
Okay.
Thank you. Miss Adams, if you
Thank
want to
you.
come grab some files, you could do that. All right, so I have Mr. Wainscott, is that you?
Yes, ma'am.
Oh, and who's with you?
Caitlyn.
Okay.
Reamer.
Okay. Okay, so, all right, I guess we'll just start with, I don't know. In the matter of the people of the state of Michigan versus Benjamin Kaylen Wainscott, file number 24-21932FH. I have Douglas Hartung appearing on behalf of the people and Elias Mawad appearing on behalf of Mr. Wainscott. Mr. Mawad, I do not have fingerprints for Mr. Wainscott. I do have an order that was signed and dated February 14th of 2025 for them to get fingerprints at the Morenci Police Department. So, Mr. Wainscott, have you been fingerprinted by Morenci yet?
I went there 3 times, and the sergeant, I think he was a sergeant working, says we do not do fingerprints here. Is exactly what he said. I said, can you put that on record? I mean, do I got to call 911? He said, no, I'm gonna put it on record that you showed up, you came here multiple times. And I said, because I showed him the paperwork. I said, it's court ordered right here.
Okay, Mr. Hartung, evidently Morenci doesn't do fingerprints. Can I order him to go to the sheriff's department or the jail?
Take a shot at it, Judge. Let's see what happens. I know he actually has tried to do this. I'm aware of that.
Miss Adams, where should I send Mr. Wainscott and Miss Maynard to get fingerprints? Do you know?
Judge, I think it's up to that department to contact APD. I believe they normally are supposed to do and meet them there. But if you want, I'll send a copy to the jail if you want to send them over there. We'll try that.
I think Adrian does them for.
Okay, so evidently the Adrian Police Department does fingerprints for Morenci. So you two need to contact or go into the Adrian Police Department and ask for whoever and schedule fingerprints. They don't do them all day, every day. They do them like certain days of the week. So you need to call APD and tell them that you need to be fingerprinted for Morenci, okay?
Yes, ma'am.
And we will send the orders over there. All right, so Mr. Mawad, with regard to Mr. Wainscott, what are we doing today?
Your Honor, on the Hudson case, he's going to be pleading guilty.
Hold on, let me get files so I know which one's Hudson and which one is, okay, so hold on. Okay, so felony information. All right, so the Hudson file is 24-21932FH. So what is he going to be pleading to?
On that case, Judge, he's going to be pleading to the larceny in a building, the 4-year, and then all other counts and habitual subs, if there are any, are dismissed. Initial incarceration capped at 1 year.
Okay, hold on, because I do not, hold on. I do not have a larceny on that file. So on the Hudson file is count 1, 2, 3, B&E with intent, count 4, burglar tools, and count 5, oh yeah, I found it, count 5, larceny in a building. All right, I misspoke. It was tucked up under the staple. So he's gonna plead to count 5, larceny in a building, no subs, and nolly cross the rest of them, right?
Right.
And then what else?
Initial incarceration capped at 1 year, Judge,
All right,
and restitution.
okay, let me get that. And then on file number 24-22089FH, what's he doing on the Morenci file?
He's going to be pleading to the B&E, the 10-year on that one.
So count one, breaking and entering a building with intent, nolly cross the rest and
No,
subs,
yep, correct.
and cap at 1 year jail
Yep.
restitution. Okay.
Yep.
All right, so because I am suffering from allergies and breathing 1 year jail, I'm going to call the other case now, and then I'm just going to do their advice of rights all at one time. So, in the matter of the people of the state of Michigan versus Caitlyn Marie Reamer. Once again, Miss Reamer, we don't have fingerprints on you. So you also, we're going to send the fingerprint orders over to APD. So you both need to contact APD and get these fingerprints done. All right, so on file number 20, or this is 24-21933FH and 24-22088FH. Mr. Mawad on 24-21933FH, that's the city of Hudson file. So what are we doing on that file?
Judge, she's going to be pleading to larceny in a building, the 4 year.
Yeah.
All other counts and any habitual subs are dismissed.
All right.
Initial incarceration capped at 1 year.
Okay.
Restitution.
All right.
And no, Mr. Hartung does not take a position. However, you're the person that's going to decide it, whether or not she gets HIDA.
Okay.
And that's for her plea on that case.
All right. What about 24-22088FH, which is Morenci? Is she pleading to anything on that one?
Yes, she's pleading to the larceny in a building, the 4 year, Judge.
Okay.
And all other counts in habitual subs, although I don't think she has it. Well, all the other counts in any habitual subs are dismissed.
All right. Restitution.
Restitution capped 1 year.
Okay. Okay, so I've got your files organized now. Miss Rener and Mr. Wainscott, are you currently being required to drug test?
No.
Okay, so Mr. Oh, where'd Mr. Mawad go? I think I lost Mr. Mawad.
Yeah, he
Probably got.
disappeared.
Yeah, he's in a courthouse somewhere, so he might. There he is. I got him back.
Sorry.
It's okay. I figured some bailiff dragged you off somewhere. All right. So, Mr. Mawad, it doesn't look like there are any bond conditions for drug testing and being monitored. So I am going to add bond conditions not to use any illegal controlled substances and a test. And Ms. Adams, could you have Darren Coast log on, please? Okay, all right, and we'll set that up through our pretrial services coordinator, and you can do that in Hillsdale as well.
Hey, Judge,
just to let you, yes,
can
sir.
I just ask Caitlyn or Ben, you're going to start drug testing, just so we know now, anything in your system, non-prescription drugs or weed or anything like that, you're not going to be in trouble. We just need to know.
No.
Ben?
Okay.
No. Okay.
So if the first time you test you're positive, I'm not going to violate your bond conditions, but moving forward, I'm going to want you to be negative, because obviously these cases always stem from drug abuse issues. So Mr. Hartung and Mr. Mawad, I also wanted to make you aware that there's going to be a law that changes in Michigan starting May 1. We will be mailing out advice of rights, and the clients will have to sign them for felonies. But also, if during the time period from the time of entering a plea to sentencing, if they violate their bond conditions, fail to appear, or anything of that nature, I am not bound by any sentencing agreement anymore. So I just want to make sure you're aware of that update in the law. But it doesn't apply to you because you're taking a plea before May 1, okay? So I want you both, okay, so Benjamin Wayne Scott, I want to see you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yeah, I do.
Okay, Caitlyn Maynard, I'd like to see you now. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, so I'm going to go through the advice of rights, and then I'm going to ask you individual questions, but I only want to read through this once for both of you. So you have heard the statement, Mr. Wayne Scott, of your attorney. Is it your intention then to plead on file number 24-22089FH to, wait, that was count 3 larceny in a building, right? I think. Yeah, was that right? On the Hudson case, it was larceny or Morency was larceny in a building?
Yes.
Or no, or the B&E?
So Ben, it is,
Morency
sorry,
is
Judge.
B&E?
The for Wayne Scott on the Hudson case, it is larceny in a building 4-year. On Morency, it's the 10-year B&E.
Yeah, okay. So Mr. Wayne Scott, on that file, is it your intention to plead guilty to count 1, breaking and entering a building with intent, which carries a maximum penalty of up to 10 years in prison? Is it your intention to plead on that file, Mr. Wayne Scott?
Yes, ma'am.
So you'll plead guilty to that count. And then on file number 24-21932FH, Mr. Wayne Scott, is it your intention to plead guilty to count 5, larceny in a building, which carries a maximum penalty of up to 4 years in prison?
Yes, ma'am.
All right, Ms. Maynard, on file number 24-21933FH, is it your intention to plead guilty on that file to count 3, larceny in a building, which carries a maximum penalty of up to 4 years in prison?
Yes, ma'am.
Is it your intention on file number 24-22088FH to plead guilty to count 3, larceny in a building?
Yes, ma'am.
Are you satisfied with Mr. Mawad as your attorney and the advice that he has given you?
Yes.
Okay, take your hand away from your face because it kind of muffles your voice a little bit. All right, Mr. Wayne Scott, are you satisfied with Mr. Mawad as your attorney and the advice that he's given you?
Yes.
Okay, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence other than the agreement with the court. Is that correct, Mr. Hartung?
That is correct, Your Honor.
Mr. Mawad?
That is correct.
All right, so if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have a right to testify at your trial if you want to testify. If your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial. And any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Mr. Wayne Scott, do you have any questions about the rights that I've given to you?
No, Your Honor.
All right. How do you wish, Mr. Wayne Scott, on file number, let me see. Okay, hold on. And Ms. Maynard, do you have any questions about the rights that I've just given to you?
No, ma'am.
All right, so Mr. Wayne Scott, how do you plead to the charge on file number 24-22089FH that on or about July 25 through July 29 of 2024 in the city of Morency in the county of Lenawee that you did commit the offense of breaking and entering a building with intent? Guilty or not guilty?
Guilty.
All right, and on file number 24-21932 FH, how do you plead to the charge that on or about June 1 of 24 in City of Hudson in the County of Lenawee, that you did commit the offense of larceny in a building? Guilty or not guilty?
Guilty.
All right, and then Miss Maynor on file number 24-219. Let me see Miss Maynor. All right, on file number 24-21933 FH, how do you plead to the charge that on or about June 1 through August 3rd of 2024 in the City of Hudson in the County of Lenawee that you did commit the offense of larceny in a building? Guilty or not guilty?
Guilty.
And on 24-22088 FH, how do you plead to the charge that between the time period of July 25 of 24 through July 29 of 24, that in the City of Morenci in the County of Lenawee that you did commit the offense of larceny in a building? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to make you induce you to plead guilty to this charge, Ms. Maynor?
No, ma'am.
Mr. Wainscott, has anybody made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
All right, Mr. Wainscott, do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Yes, ma'am.
And Ms. Maynard, do you understand that as well?
Yes, ma'am.
All right. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendants to plead guilty? Mr. Hartung?
No, Your Honor.
Mr. Mawad?
No, Your Honor.
All right, Mr. Wainscott, other than the agreement that was placed on the record, has your attorney promised you any particular sentence or estimated what your sentence will be outside of the agreement placed on the record?
No, Your Honor.
And Ms. Maynard, has your attorney promised you any particular sentence or estimated what your sentence will be outside of the agreement that was placed on the record?
No, ma'am.
Ms. Maynard, is it your choice to plead guilty?
Yes.
And Mr. Wainscott, is it your choice to plead guilty?
Yes.
All right, so Mr. Wainscott, we're gonna start with file number 24-22089FH. Mr. Wainscott, during the time period of July 25 of 2024 through July 29th of 2024, were you in the City of Morenci in the County of Lenawee?
Yes.
All right, and at that time, did you enter a building on 555 West Main Street in the City of Morenci?
Yes.
Was that a warehouse?
Yes.
All right, how did you go in the building?
Through the door, the back door.
Was it locked or was it open?
It's one of those doors that you push and from the inside push and it just opens up. But so it was shut. It wasn't like padlocked or deadbolted or anything. But
so Mr. Coach, do you want to zoom? Because I'm gonna have to put you in a breakout.
Absolutely.
Okay, so you opened it though to gain access to the building.
yes, ma'am.
You had no authority to enter that building.
No, ma'am.
Right, and was your purpose in entering that building to steal stuff?
Yes, ma'am.
Are you satisfied, Mr. Hartung, on that count?
I am, Your Honor. Thank you.
All right, so we're gonna move on to file number 24-21932FH. So Mr. Wainscott, on June 1 of 2024, were you in the City of Hudson in the County of Lenawee?
Yes, ma'am.
All right, and at that time, did you enter a warehouse there for the purpose of stealing copper wiring?
Yes, ma'am.
Did you have any right to enter that building?
No, ma'am.
And how were you getting in and out of that warehouse?
Same way, just through the back door, side door.
All right. Okay, Mr. Hartung, are you satisfied on that count?
Yes, Your Honor.
All right. Has on these two files with Mr. Wainscott, has the court complied with MCR 6.302 B, C, and D? Mr. Hartung?
Yes, Your Honor.
And Mr. Mawad?
Yes, Your Honor.
Okay, so now I'm gonna go on to Miss Maynard now. So Ms. Maynard, we're gonna start with file number 24-21933FH. So Ms. Maynard, on the time period between June 1 of 24 through August 3rd of 2024, were you in the city of Hudson in the county of Lenawee?
Yes.
And at that time, did you enter a warehouse on 432 East Main Street in the city of Hudson?
I didn't enter the building
Judge,
at all.
she aided and abetted and was the lookout.
Yeah,
That's what it is.
Okay, so you stayed in the car and were the lookout while Mr. Wayne Scott and the other gentleman entered the building, right?
Yes, ma'am.
And did you know that they were entering the building for the purpose of stealing things?
Yes, ma'am.
All right, are you satisfied, Mr. Hartung, on that file?
I am, Your Honor.
Okay, so let's move on to file number 24-22088FH. So Ms. Maynard, on or about the time period of July 25 of 24 through July 29 of 24, were you in the city of Morenci in the county of Lenawee?
Yes, ma'am.
And did you enter a storage building in the city of Hudson?
Same thing, Judge. She was the lookout. Same thing.
All right, so Mr. Wayne Scott and another gentleman went to that building with the purpose of going in and stealing things, and you sat in the car to keep lookout for police or anybody else?
Yes, ma'am.
And what were you supposed to do if somebody pulled up?
I believe I was just calling and letting them know.
Okay, and so you knew that the reason they were going there was to steal stuff?
Yes, ma'am.
Are you satisfied, Mr. Hartung?
I am, Your Honor. Thank you.
On these two files, has the court complied with MCR 6.302 B, C, and D? Mr. Hartung?
Yes, Your Honor.
And Mr. Moad?
Yes, Judge.
Okay. I accept the plea. It has been given, both pleas, if I haven't said it, they've been given understandably, voluntarily, and accurately. Both defendants have full knowledge of their rights. They do have competent counsel. Other than the agreement that was placed on the record, this court has made no other agreement regarding the possibility of a plea or possible sentence, in this case, with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them outside of the Killebrew agreement. I'm going to refer this matter to the probation department for a pre-sentence investigation, and I am going to set sentencing for May 16 at 8:30 in the morning. Let me find Mr. Mawad. And
yes,
you're available that day. You're gonna have a busy morning here. So May 16 at 8:15 8:15 in the morning. So Mr. Wayne Scott and Miss Maynard, you have a right to be present in person, or you can appear via, well, they're going to jail potentially.
Well,
so I'm gonna need you to appear in person. Is it all right if Mr. Mawad zooms in, or he'll meet with you in advance, but he may zoom in or he may be here in person. But I'm not saying you're going to jail. I'm just saying you might go to jail, and your attorney is gonna try to do his magic like he always does. So I am going to require that you be in person for sentencing. And so a couple things today. I'm going to put you in a breakout room with Jennifer Walsh from the Michigan Department of Corrections, along with Darren Coast, who I have to let in. Because
Ms. Walsh, just so you know, I think she was 25 at the time these all occurred. It's up to your office, and obviously the judge is regarding HIDA. I know that Doug is not objecting to it, but again, we're going to look for your opinions and your wonderful PSIs that you do, and then the judge's opinion, okay?
Okay. So Mr. Wayne Scott and Miss Maynard, I will put you in a breakout room with Jen Walsh. She'll get some contact information from you and give you instruction on the pre-sentence report process. And then Mr. Coast is also going to be put in that breakout room, and he's going to be managing your bond conditions. Mr. Coast, they may or may not have a first positive test, but I've explained to them after that they should be clean for any illegal controlled substances. They may need services offered to them. We have that availability as well. So when you meet with Ms. Walsh, I need you to be truthful about your background, the events that occurred, and your substance abuse, because we do provide services here for people that have substance abuse issues. We'll send the pre-sentence report to Mr. Mawad. He's really good. He'll send a copy to you, review it with you before sentencing, and we will see you back here in person May 16 at 8:15 in the morning. So, anything else, Mr. Hartung?
No, thank you, Your Honor.
Okay, Caitlyn, you were raising your hand. What did you want to say?
I was 24 when that
24.
happened.
Okay.
Yeah.
My apologies. I made you older. Sorry about that.
No, you're good. I just wanted to make sure that was known.
Caitlyn and Ben, you got to be very honest with the probation department regarding your addictions. You understand that?
Absolutely.
And don't mess
Okay.
with Mr. Coast. He's not very nice.
Don't look nice. No, just kidding.
All right.
All right, so I'm gonna open up that breakout room. When you're done speaking with Ms. Walsh and Mr. Coast, you're all set. Understand if you don't comply with the bond requirements, that could be a violation of bond conditions. So go ahead and join that breakout room and you can leave when you're done.
Thank you.
Thank you.
Thank you. Ms. Adams, if you want to come get any of these files, I got a big stack going. Okay, let's see who I got. I got Rhonda. No, I lost Rhonda. I got Sam. Anybody have Sam Milaro in here as an attorney? Why don't you come on up? What's your name?
Amy Kloff.
Say it again.
Amy Kloff.
Okay. Got it. Mr. Milaro, I have Miss Kloff and Kloff, right?
Yes.
All right, stand right in front of that podium. This is in the matter of the people of the state of Michigan versus Amy Lynn Kloff, file number 25-22154FH. I have Salvatore Milaro appearing on behalf of Ms. Kloff, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial conference. Mr. Milaro, how would you like to proceed today? I'm on a roll if you want to take a plea.
I would love to, Judge, but I'm going to ask to adjourn this briefly. I received a pretty reasonable plea offer from Mrs. McClure late yesterday, and I'd like to have Ms. Kloff into my office to review it with her.
Okay, so Ms. Adams, I'll need a notice of hearing from Ms. Kloff. My next available date is April 30th. Would that work?
Is that in the morning? Right?
Yeah,
Yeah,
8:30 in the morning.
That's fine.
All right. So Ms. Kloff, I'm going to set this over to April 30th at 8:30 in the morning. Do you know you can appear via Zoom?
I was in Zoom and I was already on my way. I actually went upstairs.
Okay, it's been a busy morning, so yeah, we've had some.
It's a Wednesday by chance.
Huh?
Is the 30th a Wednesday by
Yes.
chance? Can Wednesday mornings, I have family treatment court in Hillsdale. I actually missed it this morning.
Okay, yes, we can give you another date. So she's in a treatment court out at Hillsdale, Mr. Milaro. So Miss Adams, can I set this for Thursday or Friday morning?
Okay.
Miss Adams, could I set a Thursday or Friday morning for this? Maybe April, maybe May 1 or 2, Miss Adams?
Judge, I'm off those 2 days.
All right, maybe May 8th or 9th, Miss Adams?
Yeah, that'll work, I think.
Work on those days. You could do.
Okay, maybe, how about April 29th, Miss Adams,
Yes.
at 8, yeah?
At 8:15, yes.
Sure. So April 29th, Mr. Milaro?
That should work, Judge.
All right, so we're gonna do it Tuesday, all right? So
Okay,
April
that works.
29th at 8:30 in the morning, and just have a seat right behind you and we will get you a notice of hearing, okay? Are you okay?
Yeah, pregnant. My belly's just feeling it this morning.
Okay.
I ate and it's not settling well.
Okay, no, right there, have a seat right behind us. Yep, right behind you, there you go. We'll get you a notice of hearing, all right. So, let's see, let's see, blah, blah, blah. Milaro, everybody always thinks the public defender is still under the courts, but they don't realize that you guys are a separate office. A separate leadership now, that one gentleman. All right, Kaylee Lake. It's Rhonda Underwood. Let me see. Good luck. Good luck in family court.
Thank you.
You're welcome. Got it? All right, so. Remember. Oh, I got Malika Rumbert. I have Motorola device I just let in. If you want to unmute your device and tell me who you are.
Alexia Row.
Who is it?
Alexia Row.
Okay, I'm going to change your screen name. Your attorney is Mr. Murphy, and are you covering for him today? Mr. Malaro is Mr. Murphy down the hall.
Judge, I believe Mr. Murphy is working. I don't know where he's at the moment.
Oh, he's probably down the hall. It's okay. All right, so Miss Rowe, I'm going to pop you in the waiting room, and when your attorney is done next door, he'll come over. All right?
Okay, thank you.
You're welcome. All right, Malika Rember, why don't you go ahead and unmute your device?
Okay.
Okay, good. So this is in the matter of the people of the state of Michigan versus Malika Natalia Rembert. File number 24-21966FH. I have Salvatore Malaro appearing on behalf of Ms. Rembert, and I have Isaac Sneed appearing on behalf of the people. So, Ms. Rembert, you are currently not in custody. Are you at Harbor Light now?
No, I finished that program.
Good, good. All right, Mr. Malaro, how do you want to go today? Proceed today.
My notes are not really very clear on Ms. Rembert's case, but I know I just resolved a matter she had down in district court. So I'd ask for just a brief adjournment so I could talk to the prosecutor, Ms. Rembert, and see if we can get this resolved.
I know this is like our 6th pre-trial. Mr. Sneed, is there a plea offer in this file?
Yes, Your Honor, if I could have a moment. Was plea to counts 1 and 2, dismiss count 3, and the sentence would run concurrent with any violation of probation sentence.
And Ms. Rembert, how old are you?
24.
Right, would she be eligible? Well, she's eligible for HIDA as well, Mr. Sneed, correct?
I don't know her criminal history offhand.
I don't think she has any prior
It appears she would
felonies.
be.
All right. Okay.
There's a prior.
Go ahead.
Let's say there's a prior resisting and obstructing case from 2022, but I don't know the resolution of that.
All right, so potentially she could be Mr. Malaro. All right, so Mr. Malaro, I will set another pretrial for April 23rd at 8:30 in the morning. Obviously, if she decides to avail herself of a plea, I'd love to do it on a day other than a Wednesday. So you can come in anytime. All right,
Sure.
So Ms. Rembert, I just want to check something with you. I don't want you to put your address on the record, but is your house number still 805?
No.
All right, okay, so I'm gonna put you in a breakout room real quick with Mr. Malaro, and if you give him your valid address, or here, I'm gonna send you a chat. How's that? I'm gonna send you a chat, and I need you to text me back what your address is so I can make sure we have it to mail notices. So do you get my message? It says, what is your address? Now go ahead and type your address in, and I'll write it down. And then I'll.
Okay, I'm typing it right now.
Okay.
Okay, I sent the chat back.
Excellent. So I've got that, and I'm going to share that with Mr. Malaro as well. And that's Adrian, right?
Yep.
All right. I will send that over to Mr. Malaro as well. We'll mail your notice to that address, and we'll see you back April 23rd at 8:30 in the morning, if not sooner. Okay.
Okay, thank you.
Malika, come see me tomorrow if you can.
Okay, I will.
All right, thanks.
Yeah, bye.
Thank you, Judge.
All right, Mr. Malaro, let me send you her address real quick.
It's in the chat, Judge. I got it.
Oh, she sent it to everyone. Okay, got it. All right, thank you. All right, so that takes care of that. We have, Alexia Row. I have jail windows open. Let's start at the beginning, Mr. Malone, and see if we can get out of here. So I took care of that one.
Judge, I only have a Navy Turner. Is she in the courtroom?
Navi Turner, no, aren't they in,
She's not in
I thought
jail.
no? All right,
So we had a judge, we I believe have a plea agreement. She indicated to me that she was willing to take the plea offer. I'm kind
do you
of
want to call
surprised.
her real quick?
If I could,
Yeah, go ahead.
thanks.
Okay. Are you a student?
I am.
Where are you from?
Senior Heights, Your Honor.
Oh, okay.
So, guys for knowing.
Oh, yeah. I'm gonna stop the recording. We don't need that anymore. So. Adams, did we get a waiver on Summerfield?
Well, I missed
Mr.
it.
Malaro, did you get a hold of her?
Judge, I left a message. Hopefully she'll call me back in the next few minutes.
Because I don't have Miss Wagner. I think it's Wagner, so that must be Amanda Wagner. Okay, so Kaylee Lake. Let's round up.
I also had told her to zoom in, Judge, just in case.
Okay, that's fine. Hold on, in Judge Olsaver's courtroom. Let's go see. Mr. Murphy is not busy. All right, Rhonda's talking. He's Mr. Malaro.
Yes, Your Honor.
Could you text Mr. Murphy and say if he's between cases, I have like a bunch of his people here.
Yes, I will do that.
I don't see him on Judge Olsaver's screen, so. I wonder if the people that watch that are popping in on both of them like have two screens going up so they can watch everybody's YouTube. I don't know. Yeah, I'm gonna step off the bench for a second too. So Joanne, you might want to stand up too. Thank you, Judge.
That's a pretty top.
Oh, thank you.
It looks comfortable.
It is.
Please rise for court's session.
I think I scared the college kid away. Oh, now Mr. Murphy's in front of Judge O.
Judge,
Okay.
Mr. Murphy said he's in Judge Olsaver's court still.
Yeah, he must have been in a breakout room when I looked a minute earlier because I didn't see him, so. But he's in there now. All right, so Mr. Malaro, you've had contact with Navi Turner?
Yeah, we have, Judge. We've been going back and forth. She's been to my office. She sent a message Monday that she would accept the plea offer. Mrs. McClure sent those documents over yesterday. So this is not, I mean, she's always been.
Yeah, I don't show
involved
that
in
she's failed to appear. So I'm gonna set it over for one more date. I'll set it over to April 23rd. If you get a hold of her and you want to bring her in sooner, just let us know and we'll fit you in, all right?
Yeah, that would be great, Judge. I appreciate it. I'll do the
Alright,
stipple
and-
order.
All right, thank you. And Mr. Sneed, you can sign your name with permission. All right.
Mr. Sneed's
Okay.
getting coffee apparently.
I'm sure. All right, so you are all set. I just need Rhonda Underwood and Mr. Murphy, and I'm good.
Thank you, Your Honor. Have a good day.
You too, thank you. All right, I'm gonna wonder, if that can let me know if I come in.
Yes.
We're trying. I have to leave today at 11:30. Okay. Okay. Mr. Murphy, let's start with Alexia Row. I have to leave at 11:30 today, so Becky, could you let the jail know I'm ready on William Powers, Jackie Smith, or never mind, I'll call.
I'm right here. Powers, Smith, who was the other?
Oh, yep, I'm ready for, let's do, Powers, Smith, Lambley. And I think that's all I have. Yep.
Okay, I'll get them around.
Thank you.
Yep.
Judge, you have Summerfield too.
Yep, I've never gotten an attorney in on that, so I don't know what's going on Summerfield. All right, so I've got Alexia Row. Why don't you start your video, please? Okay, this is in the matter of the people of the state of Michigan versus Alexia Jovan Row, file number 25-22136FH. I have Matthew Murphy appearing on behalf of Miss Row, and I have Alexander Bayonetto appearing on behalf of the people. Do you have another question from the jail or?
So I heard when I walked away, you mentioned Summerfield. You want him added after these three?
Not at this time because I don't have their attorney, so I don't know what's going on with that one yet. Thank you though.
Yep, you're welcome.
All right, so Miss Row, as I think I said, but it's file number 25-22136FH and 25-22137FH. I have a plea agreement form that states that if Miss Row pleads as charged on file number 25-22136FH, that file number 25-22137FH would be nulli prost at the time of sentencing. And let me see what else we got in here. I don't think there's any other terms to that plea. Is that correct, Mr. Murphy?
Your Honor, Mr. Bayonetto did include, and I think he may not have gave you a copy, but we're trying to get a signed copy to you. That would include that Ms. Rowe would have no upfront incarceration as long as she continues to successfully attend drug court, recovery court. If I'm not mistaken, I think that was updated one.
I do have a plea agreement form. And I'm not seeing that there's a no upfront jail term on that, but Mr. Bayonetto, is that a term?
Your Honor, I didn't include the no upfront jail. I just said that I had no objection to her continuing in recovery court.
Okay, all right. So plead as charged, enter and complete recovery report, and prosecutor, no objection, no upfront jail. Or no position, right?
No position on jail time, Your Honor. That's correct.
Okay. All right. So Ms. Rowe, okay. Is that a correct recitation then, Mr. Murphy, of the plea?
Yes, Your Honor.
All right, Ms. Rowe, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, and you are Alexia Row, correct?
Yes.
All right, so Ms. Rowe, you've heard the statement of the prosecuting attorney, your attorney and myself. Is it your intention to plead as charged on file number 25-22136 to count one, controlled substance, possession less than 25 grams of cocaine, which carries a maximum penalty of up to 4 years in prison?
Yes, Your Honor.
All right, and Mr. Bayonetto, I know she's in recovery court, but is she also eligible for 7411 if need be?
I don't know if she is or not, Your Honor.
I think she may have had a previous one under 7411. I'm not sure though.
Okay, all right. So Ms. Rowe, I guess I would ask you again, you're satisfied with Mr. Murphy as your attorney and the advice that he's given you?
Yes, Your Honor.
All right, and other than the plea agreement, there's been no other discussion on the defendant's behalf regarding a possible sentence. Is that correct, Mr. Murphy?
Yes, Your Honor.
Mr. Bayonetto?
That's correct, Your Honor.
All right, so Ms. Rowe, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Ma'am, do you understand that if your plea is accepted, you may be giving up rights, the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that, Ms. Rowe?
Yes, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
Do you understand that if you are not a citizen of the United States of America, a conviction of a plea, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization? Do you have any questions about the rights that I've given to you, Ms. Rowe?
No, I don't.
All right, Ms. Rowe, how do you plead to the charge that on or about November 30th of 2024 in the city of Adrian in the county of Lenawee, that you did commit the offense of controlled substance, possession of cocaine less than 25 grams, guilty or not guilty?
Guilty.
All right, has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Right. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Murphy?
No, Your Honor.
Mr. Bayonetto?
No, Your Honor.
Other than the agreement that was placed on the record, Ms. Rowe, has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
Is it your own choice to plead guilty?
Yes.
All right, so Ms. Rowe, let's see, back to the date. On November 30th of 2024, were you in the city of Adrian in the county of Lenawee?
Yes.
At that time, did you have in your possession less than 25 grams of cocaine?
Yes, Your Honor.
And it was your cocaine?
Yes, Your Honor.
And you had no legal right to possess it, is that correct?
That's correct.
All right, Mr. Bayonetto, are you satisfied?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D? Mr. Murphy?
Yes, Your Honor.
Mr. Bayonetto?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. I'm going to refer this matter. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation, and I am going to set sentencing in this matter for May 16 at 8:15 in the morning. Mr. Murphy, you're available that day?
I believe so, Your Honor, yes.
So Ms. Rowe, you have the right to be present in person, or you can appear via Zoom. You're already kind of interacting with the recovery court program. Is that right, if I remember correctly?
Yes.
Yeah, good. All right, so do you want to appear via Zoom or in person?
It'll probably be Zoom, because like right now I'm at work. I'm just waiting for this to get over.
Okay, so we'll have that via Zoom at 8:15 on May 16th. When you meet with the probation department, you need to be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report, And we'll provide that to Mr. Murphy. He will review that with you the day before sentencing or earlier. And then we will see you back on May 16 at 8:15 in the morning. Ms. Walsh, you want to break out room real quick?
I do, but I don't want to miss any other pleas.
I won't.
There's gonna be any other, please.
Miss, I know, I'll fill you in though, Miss Walsh. So I'm gonna open up a breakout room. And Ms. Rowe, I'm gonna pop you in there with Miss Walsh, and Miss Walsh will get your contact information, give you some instructions. It'll just take a minute so you guys can get back to work. And there you go. Go ahead and join that breakout room.
Ms. Rowe, just contact my office in a few weeks, okay? In a week or two, all right?
Okay. All right. So I got one more person I want to take who's been in my waiting room for a couple hours. I've got Kaylee Lake. Is she yours, Mr. Murphy?
No, Your Honor.
Oh, okay. She must be Miss Underwood's. All right. Miss Lake, you're waiting for Rhonda Underwood, right?
Yes, ma'am.
All right. She's on her way, so just be a few more minutes. So just be patient. All right.
Okay, thank you.
She's been in the court next door. All right. So Jackie Smith, in the matter of the people of the state of Michigan versus Jackie May Smith, file number 25-22206FH. I have Matthew Murphy appearing on behalf of Jackie Smith. Oh, I'm sorry, Isaac Sneed appearing on behalf of the people, and Matthew Murphy appearing on behalf of Miss Smith. I do have a pretrial assessment schedule that was done on April 4 by Darren Coast, who conducted a pretrial assessment with Miss Smith. She's in jail on an $1,100 bond. She did score high to reoffend or not appear for court dates in her lengthy history for criminal cases and lack of success during probation. So her bond appears appropriate, perhaps a little low, but at this time appropriate. So Mr. Murphy, how would you like to proceed on behalf of Miss Smith?
Yeah, this is an arraignment.
I'm sorry, it's an arraignment. Do you waive the reading of the felony information?
Yep, we're going to acknowledge receipt of the information, the witness list, and the discovery man at this time by the prosecution. Asking the court to set a pretrial on this matter. I think this case will be resolved by the first pretrial with a plea. So just, whatever the court finds is scheduled to fit the pretrial in, we're asking for that. We are asking the court to...
Hold on. My next available pretrial is May 7 at 8:30. Does that work for you?
That should be fine, Your Honor.
Okay. All right. And what were you going to say, Mr. Murphy?
We were going to ask the court to consider bond if the court was willing to hear an argument about bond this time.
Not at this time based on the pretrial assessment I've received, but you can file a motion if you'd like, and then we'll be back.
Can we please get a copy of the pretrial assessment? I don't think we can.
Yeah, we can have Mr. Coast email that too. All right.
Thank you, Your Honor.
All right. Thank you. All right. You're all set, Smith. We'll see.
I'll talk to you tomorrow, okay?
Okay.
Thank you.
Thank you. All right. So I have two gentlemen. Let me see. So that one done. All right. So I have a gentleman with a short beard and I have a gentleman with a long beard. So who's the gentleman with the long beard?
William Powers, Your Honor.
Okay, so let me grab Mr. Powers' file. In the matter of the people of the state of Michigan versus William Mitchell Powers, file number 24-22033FH. Says the date and time set for a pretrial conference in this matter. I have Isaac Sneed appearing on behalf of the people, Matthew Murphy appearing on behalf of Mr. Powers. Mr. Murphy, how do you wish to proceed today?
Your Honor, we're asking for a trial to be set in this matter. Probably a 3-day jury trial is what me and Ms. McClure had talked about. I wasn't sure if the court had, because we had emailed to see if, just to give the court a heads up about that. Because we're thinking it's probably going to be, quite some time before we could probably find a 3-day chunk there. But that's what we're asking for at this time, Your Honor. And then I was, based upon the time frame, I was going to file a motion to consider a bond reduction.
Right. So he's charged with 2 counts of criminal sexual conduct first degree, which carries a maximum penalty of life in prison, and then 1 count of criminal second degree, which carries 15 years in prison. Mr. Sneed, I don't know if you have access to records. I know it's a Ms. McClure file. Has there been a plea offer made in this file?
The offer was one count of CSC first and one count of CSC second.
All right. So, all right. So, Miss Adams, do you want to bring me the book? This is a 24 file. It looks like he was arraigned back in November. Okay, so give me just a second. So. So I have a 3-day jury trial scheduled June 24th on another individual who is not in custody. So Mr. Murphy, it's not your case, it's Mr. Glazer's, but he's not in jail. So June 24, June 25, and June 26.
So, Your Honor, we can schedule that. You know, I have an appointment next week. Based upon that, I mean, I may be recovering from surgery, so that's the problem I have ultimately. But I think that may be far out enough to where I'll be done by then. So if we could go ahead and do that.
Mr. Sneed, I don't know if you can see.
Yeah, Miss McClure is available at that time, Your Honor. Thank you.
Okay. Right, so we'll set a 3-day jury trial. This is my first available. Starting June 24th of 25, the first day would be at 9 a.m. Obviously, Wednesdays start at 10:30, Thursdays at 9 a.m. So if I have June 24, it's a jury trial date, I'm going to require June 11 for a final pretrial at 8:30 in the morning. And I'm going to require that voir dire questions and jury instructions be provided to the court by June 6th. Right on the side, June 6th. And then I'm going to set June 11th as a motion in limine. That's a filed and heard by date. And then I will require exhibits marked, exchanged, and submitted to the court by June 11 as well. So we can discuss them at the pretrial. So let me put June 10th, just so they come in the day before. And let's see, voir dire questions. Obviously the court does voir dire, but I would ask that those questions be provided to the court June 6th, so we can discuss them at the June 11 pretrial. That. All right, is there anything else we need to address, Mr. Sneed?
No, thank you, Your Honor.
Mr. Murphy?
No, Your Honor, I'll just be in contact. I'm concerned about me being unavailable at that, you know, it being kind of a short notice with my medical issues. So I'll just be in contact with the court if there's an issue with that time frame.
Okay, I'm assuming that that's something you'll work out between your office and the prosecutor's office.
Yeah, I'll know more next week, so we'll figure it out soon if that's gonna be a problem, so.
Yeah, and then I just know that I will not have a trial date. Well, I will in July if we get it but soon, but all right. So Mr. Powers, we will see you back on those dates, if not sooner, okay?
Yes, Your Honor. Mr. Murphy, do you mind if I go in a breakout room with you real quick?
I don't have time for you to have a breakout room with them today. He has about 3 more clients backed up and I have about 20 minutes, but Mr. Murphy is really good about scheduling appointments and meeting with people, so.
I'll Zoom with you this afternoon, okay?
Thank you, Mr. Murphy. Thank you, Your Honor. May God bless you all.
All
And have a
right,
great
thank
day.
you. Thank you.
Thank you, Mr. Powers.
So let's go to Mr. Lambley. All right. Becky, can you, well, I'll talk to you. Okay. In the matter of the people of the state of Michigan versus Noah Lambley, file number 25-22205FH. I have Isaac Sneed appearing on behalf of the people. I have Matthew Murphy appearing on behalf of Mr. Lambley. This is the date and time set for arraignment in this matter. Mr. Lambley had a pretrial assessment done with Darren Coast. Mr. Lambley also scored a 6 on the ORIS, which puts him in a high category to reoffend or not appear for future court cases. Let's see. He's been in jail since March 22nd on a $2,500 bond for tampering with a GPS device. That was required on a misdemeanor case. So, and he's currently not employed. All right, so Mr. Murphy, do you waive the reading of the felony information on behalf of Mr. Lambley?
Yes, Your Honor, we acknowledge receipt of the information, the witness list, and the discovery request by the prosecution in this matter. We ask the court to enter a not guilty plea and set a pretrial as soon as the court can find it scheduled to do so. We are asking the court to reconsider bond in this matter if possible. If we could have an argument on it today.
Okay, let's see, my next available will be May 7 at 8:30 in the morning for a pre-trial. We do the notice because it's an arraignment. I'll enter a plea of not guilty on his behalf. As I said, he did score high on assessment. He's homeless at this time. There's a lengthy criminal record across multiple states, and he's not currently employed. So go ahead and address. Okay, hold on, Mr. Lambley. Mr. Murphy, go ahead and address bond.
Your Honor, in regards to Mr. Lambley, I don't, well, this event occurred a bit ago. It didn't occur recently in regards to the alleged cutting off of the GPS tether. Now, the event itself, Mr. Lambley it maintains his innocence, that he was attacked and all objects of value were removed from him, so he was a subject of a crime, victim of a crime. Now, there is an issue that was dressed up in district court in regards to bond in this matter, is that Mr. Lambley has a pending case and he has a criminal responsibility review scheduled for, or an appointment scheduled for the 14th, Monday, for that to happen.
On this case?
On a case already pending, Your Honor.
So there was a forensic examination, a petition for competency?
He was found competent, Your Honor, but there was a pending review of a criminal responsibility on a pending case. So I don't think he's a flight risk, Your Honor. Again, I understand that the charge itself has concern, but Mr. Lambley, he's already arranged for his brother to transport him to that appointment on Monday. Speaking with him, he had every intentions of appearing to court moving forward on the previous case and on this case. I don't think that he has I didn't see a criminal history. I can't see outside of the state. So I don't know where that was coming from. So I do, I guess I will express ignorance about that, but I don't believe that Mr. Lambley is violent towards the community. Again, I think that what's being addressed here is already scheduled to be addressed with that appointment on Monday. I don't think it's necessary to keep him incarcerated. I do believe he was trying to get employment, already had employment. And with Mr. Lambley, I think that the key here was because the other case involved.
Hold on, Mr. Murphy, you're breaking up. Mr. Coast, can you log into Zoom?
Absolutely.
Thank you. All right, Mr. Murphy, you were kind of cracking and back, breaking up. So anything else?
I was just saying, I think Mr. Lambley was about to be employed or trying to, because the other case involved a destruction of property, which involves him having to pay what was destroyed. But again, Your Honor, they're just asking court to reconsider.
All right, I'm having Mr. Coast log on. He's the one that did the pretrial assessment. And he can give us some further information. Rhonda Underwood, do you need a breakout room with Kaylee Lake?
Yes, thank you.
Okay. I gotta leave here at 11:30 today, and I apologize for that. So, Miss Lake and Miss Underwood joined that breakout room. All right, Mr. Coast, you provided a pretrial assessment for a Noah Lambley. It says, it's dated April 4. You said that you scored him 6 on the Aura scale, which puts him in a high category to reoffend or not appear. You also mentioned a criminal history spanning Michigan, New York, and California. Could you give me some information on, you said lengthy criminal history spanning those 3 states. Could you provide us perhaps with more information on that?
Judge, I'd have to actually run the criminal history again. I did glance through the criminal history, and I did note those 3 states.
I was not guilty on all those charges. I've only been
Mr.
guilty.
Lambley, don't interrupt, please.
Sorry, ma'am.
Go ahead, Mr. Coast.
Yeah, Judge, I'd actually have to run the criminal history again. I didn't actually record everything on the criminal history. I just noted that he did have histories in 3 different states.
Okay. All right. And Mr. Lambley, they're not saying you were convicted, just that there have been charges against you in multiple states. All right, Mr. Sneed, your position at this time.
Your Honor, the people would defer to the court's discretion, but I think you stated the court's understanding of the history, the threat to the public here, and the case pending is a tampering with an electronic monitoring device. So I don't have anything to add to that. Thank you.
So
I have an address. I have an address, and I have a side job as a tattoo artist. I just have to get the equipment from my brother. So I am employed, and I do have an address. And I had it wrong. It's 404, not 127, Molzer Avenue. And I thought it was 127. That's my address.
All right, I do feel that the bond is appropriate in this case, and I'm not going to reduce his bond at this time. It is $2,500, and we will be back for the pretrial on May 7 at 8:30 in the morning. Thank you.
Yes, thank you,
Mr.
Judge.
Lambley.
Thank you. Thank you, Your Honor. That's all I think I had scheduled.
Hold on, Mr. Murphy. Hold on. Don't run away from me. All right, real quick. I had one. Nope. Okay. Now you can run away. Go ahead.
Have a good day.
Thanks,
Thank you.
Mr. Murphy. All right. Thanks, Mr. Coast. All right. I'm going to
I don't think he's
close.
running.
Yeah, I don't think he's running very far. All right. Let's see. And you're, of course, waiting for the last one. You know, we're live on YouTube, too.
See, I didn't know that.
Yeah, going forward.
I'm doing.
Yeah, you can just look it up because I record it and it stays up on you. We do that because we don't have a lot of public transportation in Lenawee County for people to get here. So that way victims and people in the cases can observe. All right, I'm gonna bring back Miss Underwood because I gotta leave in 11 minutes. All right, Miss Underwood, on the matter of the people of the state of Michigan versus Angelina Hall, file number 25-22152FH. Miss Underwood, Miss Hall has not appeared today. She's not been here all morning. Have you heard from her?
I have tried repeatedly to get a hold of her, Your Honor.
All right, so I'm going to issue a bench warrant for her arrest. And I am going to set bond in the amount of $50,000 cash. Okay, that takes care of that one. All right, and in the matter of the people of the state of Michigan versus Kaylee Lake, file number 25-22146FH. I've run Underwood appearing on behalf of Miss Lake, and I have Alexander Bayonetto appearing on behalf of the people. This is a date and time set for a pretrial. Miss Underwood, how would you like to proceed?
First of all, my apologies for how long it took in the other court. Your Honor, I'm going to give the court the option. The court already has a signed plea agreement from Ms. Lake for a plea today, but Your Honor, we would be willing to come back and do that.
Ms. Underwood, I can get the plea done. I don't have a plea agreement form, but what's the plea offer?
Oh, you should have it.
I don't, but just tell me what the plea is.
It is an attempted use of a financial transaction device, Your Honor, under HIDA.
Maybe I had the wrong file. Hold on. Let me see here. I did. I had the wrong file. Okay, so Yep, I do have the plea agreement. You are right. So she would plead to an added count 2 of attempted use of a financial transaction device. If she is eligible, she would be sentenced under the Homes Youthful Training Act. Is there any terms regarding upfront jail or no
I
position
believe
on
it's no
behalf?
upfront jail, Your Honor.
Okay, and no upfront jail. Okay, so is that all the plea, Mr. Bayonetto?
There is also restitution in this case, Your Honor. I don't know that I checked it on the plea form, but I would ask that the court that it be noted, at least for the record now, that restitution.
Do you know how
to
much it
be-
is?
Yes, $1,433.88. She does have a co-defendant in this matter who is on probation in district court, so I would ask that that be paid joint and severally between the two of them.
So $1,433.88.
Yes, Your Honor.
All right, anything else with regard to the plea, Ms. Underwood?
No, Your Honor.
Ms. Lake, you want to raise your right hand for me? I appreciate your patience this morning, but do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, and I know Miss Underwood was in Mr. Judge Olsaver's court because I watch his court too. And then, you know, try to trick her to come over to see me, but she doesn't usually fall for it. So you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to an amended information with a count 2 of attempted use of a financial transaction device, which carries a maximum penalty of up to 2 years in prison? Is it your intention to plead guilty to that?
Yes, ma'am.
All right, and do you understand that if you're eligible, you could be sentenced under the Homes Youthful Training Act, which means the charge and the conviction would never be on your public record if you qualify? Do you understand that?
Yes, ma'am.
Okay, but do you understand if you were to violate probation, you would lose your HIDA status? Do you understand that?
Yes, ma'am.
All right, are you satisfied with your attorney and the advice that she has given you?
Yes, ma'am.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than what was placed on the record. Ms. Underwood?
That's true, Your Honor.
Mr. Bayonetto?
Yes, Your Honor.
And Ms. Lake, is that correct as far as you're aware?
Yes, ma'am.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. If your plea is accepted, you will be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial. And any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've just given to you, ma'am?
No, ma'am.
All right. How do you plead to the charge that on or about the time period of December 28th of 2024 through December 30th of 2024 in Adrian Township in the county of Lenawee, that you did commit the offense of attempted financial transaction device stealing, retaining without consent? Guilty or not guilty?
Guilty. I'm sorry, guilty.
All
Your
right. Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
Honor. No, ma'am.
All right. Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
All right. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Mr. Bayonetto?
No, Your Honor.
Other than the agreement that was placed on the record, Ms. Lake, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right, so Ms. Lake, on or about the time period of December 28th of 24 through December 30th of 2024, did you have a financial transaction device that belonged to somebody else?
Yes, ma'am.
All right, and did you have permission to use that device?
No, ma'am.
Did you use that?
Yes.
Would you agree restitution is estimated to be $1,433.88?
Yes, ma'am.
And when you use that device, your intention was to basically cheat the owner out of that value?
Yes, ma'am.
Okay. Was it a debit card or a money gift card or what was it?
It was a debit card.
Okay. Are you satisfied, Mr. Banetto?
I am, Your Honor.
All right. And Kimberly Lake is who to you?
My grandmother.
Okay. All right. Has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has.
Mr. Banetto?
It has, Your Honor.
Accept the plea. It's been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the Killebrew. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. Lake, I'm going to put you in a breakout room here in a minute with Ms. Walsh from the Department of Corrections. She's going to give you some instructions. You're going to have to come meet with them and do an interview. You live locally, so when you meet with them, be truthful about your background, the events that occurred. They'll prepare a pre-sentence report. We'll get a copy of that to Ms. Underwood. Reach out to her about a week before sentencing. She will try to get a hold of you to review that pre-sentence report, and we'll see you back here for sentencing on May 16 at 8:15 in the morning. Ms. Lake, do you want to appear in person or via Zoom?
Via Zoom.
All right. So, Ms. Lake, you know, I hope that your grandmother forgives you and that you can rebuild her trust in you. And we will see you back on that day. Ms. Walsh, give me just one moment, and Ms. Lake, you give me one moment as well. So, Ms. Walsh, no one has appeared on Bradley Summerfield today for arraignment. And so neither has the attorney. So I'm wondering if there's a waiver somewhere. It's through a private attorney. So we're not going to do that one today. We'll reach out to them and reschedule that one. And Miss Underwood, that is your last case. So, all right, I'm going to open up
Alvin Graves.
I'm not going to do them till this afternoon. I got to go.
Okay.
So I'm sorry. We were crazy busy this morning. So, all right, so Kaylee Lake, I'm going to open up a breakout room with you and Miss Walsh. Make sure you follow her direction, and we'll see you back on May 16 at 8:15.